All right, the court is calling 2022 CR 2308, State of Texas versus Jose Raimundo Perez. Can I have the parties announced for the record for the state?
Brittany Mitchell for the state.
Defense.
Good morning, Your Honor. Albert Juarez for Mr. Jose Raimundo Perez.
And are you Mr. Perez?
Yes.
All right. All right, we have an interpreter. Could you raise your right hand for me, please?
Yes, Your Honor.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you? I'm sorry. No, that's not you. I'm sorry. I'm in my mind, I'm doing three different things because one, I'm trying to figure out what he was found guilty of with the jury. But could you raise your right hand?
Yes.
Do you solemnly swear or affirm you will faithfully translate from Spanish into English and English into Spanish so help you God?
Yes, Your Honor.
All right, you can lower your hand. Could you state your name for the record?
Yes, Your Honor. My name is Elizabeth Stonking, license number 23.
All right. All right. So state or defense, what did the jury find him guilty of, please?
I believe it was count one, Judge. The sexual assault.
Yes, it was a guilty for sexual assault.
All right, let me see if it's in the file. Just give me a moment. All right. So what I have is that the jury found you guilty of sexual assault. Any objections to the court assessing punishment, state or the defense?
Your Honor, I believe they recommended probation, but I think
Yes.
the court has to.
So no, my question is, any objection to this judge assessing punishment?
No, Your Honor, I know there was an intervening judge, but no, we don't object.
No objection.
All right, have both parties had a chance to review the PSI report, state,
Yes, Your Honor.
defense?
Yes, Your Honor.
Any objections to the PSI report, state,
No,
defense?
None from the defense judge.
All right, any witnesses, state,
no, Your Honor.
defense?
No, Your Honor.
Anything you wish to say on behalf of your client?
Judge, yes, he's obviously not a young man. He's lived his life here in the United States from the age of his early 20s. He's opened his own business, raised a family. This is, while it's a significant, obviously, mark on his record, it is the only one that he's ever had. I don't suspect that I know that there's no evidence that he's ever exhibited any kind of behavior that would let this court believe that he is a danger to society in any way, shape, or form. I believe that's why the jury assessed punishment or recommended probation. I think he's got other issues to deal with. He's a legal permanent resident, and once he gets put on probation, he's going to have to deal with those issues. He understands that. His punishment is not over. He's got to continue paying and dealing with those issues. He's been in jail already for 60 days, Judge. We're just asking that you follow the recommendation.
All right, and is there any request for a length of probation time?
Your Honor, we would ask for the full 10 years.
I think the recommendation was 8 years. I think that would be sufficient.
No, 8 years prison. But the jury has said that they recommend that be suspended and he be placed on probation.
I think I would leave that to the court's discretion.
All right, the court then will sentence you according to the jury's verdict. The court is finding you guilty of the offense of sexual assault. There's to be 8 years in the prison, suspended for 10 years. Chapter 62 registration. There's to be no contact with the complainant. There's to be regular reporting by Zoom or in person, regular UAs. There's no community service hours that I can give him that they'll allow him to take based upon his Chapter 62 registration. So the court is not going to order community service restitution, and that is why. proof of employment within 30 days of release from custody. There's to be no employment as a home health care provider or with minors. Field visits one time per month. There's to be no unsupervised contact with minors. And there is, oh, that's it. Anything else, probation?
Judge, did you want field visits?
Yes, thank you. Field visits one time per month.
Your Honor, the victim has undergone counseling because of this, so we would ask for any restitution that she's had to pay out of pocket for counseling services.
We don't oppose that, Your Honor. I do have an issue with the no contact with minors. I believe one of his daughters.
No, it's no unsupervised contact.
No.
All right, restitution for counseling to the complainant. And so with regards to that counseling, if it's covered by insurance, of course, that's the insurance company. But if it's something that's out of pocket for her, he'll have to pay for it.
Yes, sir.
And there will be suitable documentation, I'm sure, shown to defense counsel to show that it's out of pocket. Probation, anything else that he needs? All right, Mr. Pettis, is there anything else you need from the court in order to be successful?
No.
No, ma'am.
All right, did you review the document with your attorney entitled Trial Court Certification of Defendant's Rights to Appeal? Did you sign it and did you understand it?
Which one? I did not understand.
The Trial Court's Certification of Defendant's Rights to Appeal.
It's been too much, Your Honor. I don't know if you could show it to him. I'll see.
Oh, yes.
All right. And counsel, do you speak Spanish?
I do, Your Honor.
Do you speak it fluently?
I do, Your Honor.
And were you able to communicate with this document that's in English with your client in Spanish?
I was, Your Honor.
And do you believe he understands it?
I do believe so.
All right. Because this was not a plea bargain agreement, because this was a jury trial, you do have a right to appeal.
And he's already been informed, Your Honor, that he has 30 days to effect that appeal if he so wishes.
And were you, I'm sorry, were you retained or?
I was retained. Yes.
All right, so if there's anything that needs to be filed, if he needs a court-appointed attorney, once everything is filed, we'll make sure he has one.
Yes, Your Honor.
All right, Mr. Pettis, if there's an issue with probation, let the court know. We're here Monday through Friday, but in this court, in order to be successful on probation, communication is key. So anytime you have an issue or something that you need that's not being given to you, let probation know. If that problem is not solved, let the court know. All right, is there anything else from either side?
Nothing much.
All right, yes.
We do have victim impact.
Okay. All right, Mr. Pettis, they have victim impact. So the complainant will speak to you. Just listen to what they have to say and internalize it.
For 2 years now, I've tried to piece together the words of what I'd say when this moment came. I need to start by letting you know that we forgive you. We don't hate you. Not at all. Ray told me to let you know that he does not hate you. We hate what you did. And with that being said, you do deserve the punishment, whatever it may be. I looked forward all my life to the family that I would one day marry into. The friendship between the siblings and the mother-in-law, and you stole that from me. Because of their loyalty to you, I've been treated differently and outcasted. When prior to all of this, we did have a beautiful bond. It was like having a fairy tale ripped right out of my hand. And we will never be the same, not any one of us. I will never understand why you did what you did. I thought so many times, what if I tried to hear you out? But the answer always comes back to the same thing. It doesn't matter why it happened. I carry a burden and a guilt that I never deserved. The shame is yours to carry, not mine. Everyone stands behind you as if I'm someone to blame. Your wife, your children, everyone has stood behind you this entire time. And they've outcasted me as if I did it. Because of your decisions, you've forever lost your son. We have two beautiful children now that you won't ever get to know. My babies have to grow up without their grandfather. Your wife lives in constant anxiousness. Your daughters are broken in different ways. You made it to where I can't trust the people closest to me. You stole my confidence and my self-esteem, and you made me feel unworthy of your son. You filled me with anxieties that I can't escape from and nightmares that occurred for several weeks after this happened. Your son lost his role model, he lost his father, and he lost his closeness with his siblings. He wanted me to let you know that he loves you and he misses you and that he wishes that this had never happened so that you could see there to share these experiences with him. We just pray that you repent and that you find salvation and that you make better decisions in the future.
Isaac Lopez, 2020 CR 2993 and 2023 CR 043W, State of Texas versus Adrian Soto. Could I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense,
David Andre Woodard from Mr. Soto.
are you Mr. Soto? And cause number 2020 CR 2998. You enter a plea of no contest to burglary of a habitation with intent to commit assault. According to the plea bargaining agreement, punishment is to be assessed at 8 years in the prison, and the state is opposing your application. And cause number 2020 CR 3661, you entered a plea of no contest to the offense of assault, bodily injury of a security officer. According to your plea bargaining agreement, the state is requesting that punishments be assessed at 8 years in the prison. They're opposing your applications. Have both parties had a chance to review the PSI report, state? Defense?
I have, Judge.
Any objections to the PSI report, state?
No objection.
Defense?
No, Your Honor.
All right, any witnesses, state?
None from the state.
Defense?
No, Your Honor, aside from the letters that are provided to the
All right, and for the record, the court has reviewed the letters that have been presented. The court will hear arguments, state.
Your Honor, based on the defendant's criminal history, he did pick up these felony cases as well as multiple misdemeanors that are also pending involving the same family. The defendant's conduct is escalating and continues to terrorize the family, including the complainants on this case, as well as her brother, her children, and her mother. And the burglary for habitation, a burglary to a habitation case, defendants alleged to have entered the house through a open window or through an unlocked window and grabbed the child from where he was sleeping at 3 o'clock in the morning. He's shown a disregard for the safety and welfare of the complainant as well as the children in the household. And it's the state's fear that if the defendant were granted probation, he would continue to contact the family, continue to violate any no contact orders that would be entered. I would believe that the only way to ensure the safety and the welfare of the complainants are to sentence the defendant to the prison.
Defense?
Judge, I reviewed the PSI and also talked to Mr. Soto this morning regarding the impact statement as provided in the PSI, and I've asked him, since this incident, had he had any contact with the complainants? And since the incident, he stayed away from them. He does have 2 children with the young lady. He hasn't seen the children because of this incident, but he has not gone around them or their household. So I think he's shown that he can stay away from them. I don't think he needs prison to stay away from them. Since he's been on bond, since these cases have been pending, he stayed away from that family. Also, Judge, if you look at his prior history, he does not have any convictions for misdemeanors or felonies. He's 25, he is working. He has support. He has family members here in court with him this morning. He has the letters that were provided to him. I think when we pled on the case, Judge, the court asked him if he was experiencing any substance abuse issues at the time of the offense. He was truthful with the court. He said, yes, Judge, I was under the influence. I also asked him this morning if the court did testing, how would he come up? And he explained to me he would come up negative. He has not been using any type of substance since he's been on bond, since these cases have been pending. He is working. He's working as a painter. He's not on child support for the children, but he is willing to place himself on child support so he can start contributing to their well-being. Also, Judge, the TAP evaluation, I noticed that it is recommending inpatient treatment. If the court did grant his application for deferred, we would ask the court to first see how he does in intensive outpatient treatment, because he's shown that he can stay drug-free. But I do think he would need some assistance with that, even though he's been doing it since he's been on bond. We would ask the court, if the court did grant his application for deferred, to place him in intensive outpatient treatment prior to placing him in inpatient treatment. He accepted responsibility for both offenses. He pled to these cases. And now we're here before the court, asking the court to grant his applications for deferred.
All right, so this is the court's issue. And not really an issue, but these are things that I think of. All right, so he has a felony offense, and I'm assuming this is being taken in consideration. The violation of an order, protective order. That's from December 31st, 2019. The burglary that he pled to is from December 27th, 2019. So let me go in order. So he has a continuous violence case that's December 14th, 2018. I'm not saying it's true because nobody pled to that, but that's what he's charged with. Then after that, you would think something would click. Hey, I just got arrested, because I know he would have gotten arrested on that and made bond. And he would have gotten an attorney. So you would have thought that something would have clicked with that. But what ends up happening is on December 27, 2019, he picks up this burglary. Then you would have thought something clicked with that. But then what ends up happening? He picks up the he picks up the violation of the court order or bond order or protective order on December 31st, 2019. And you would have thought that it would have been like, hey, I need to be on my P's and Q's because I picked up all these felonies. I understand relationships, and sometimes people don't love each other anymore and they have children and they got to make it work for the children, or they got to stay respectful to each other because they got to raise children together. And as everybody know, even though people say, we only need to be with each other for 18 years, but people know sometimes you need to be with certain children till they're like 25 or 30. I understand that. But then what ends up happening? He ends up picking up another case that he pled to, which is the assault case, on September 17th, 2022. So he has some issues. And I don't think that probation at this time is appropriate for him. Is he on GPS?
He is judge, and since he's been on GPS, he has not violated the GPS.
Oh, because he's on GPS because of this. And I'm not the judge who gave him probation for continuing to pick up cases. Some other judge did that, and the only thing I came back to do was probably add the GPS so that everybody would know where he was. So I'm not inclined to give him probation. I'm not going to give him probation. I'm going to sentence him, and I will retain jurisdiction. So in cause number 2020 CR 2998, court will find you guilty. Court will sentence you to 5 years prison. Give you credit for any time served. There's a $1,500 fine. Time and money will run concurrent. This will run concurrent with 2023 CR 0463W. Take in consideration 2022 CR 3661, 2021 CR 3086, night mag number 679462. The following county court cause numbers: 634960, 6048888, 630200, 634987, 634989. There's an affirmative finding of family violence. There's to be no contact with Augustine Olvera, Olvera, Elvira Olvera, Galilea, Gaililea, Olivera, and John Mello, Mellow. Give you credit for any time served. And that cause number, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and also affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. And cause number 2023 CR 0436W, court is finding you guilty, sentencing you to 5 years in the prison. Give you credit for any time served. This will run concurrent with 2020 CR 2998. There's to be no contact with Bentley, Bentley, Beer, Ber, Garden. Court will give you credit for any time served. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney?
Yes, ma'am.
Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand? Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. You understand? All right, we can go off the record. I'll retain jurisdiction.
Both cases, Judge?
Yes. Sometimes, it is about rehab. Well, it's always about rehabilitation, but it's also about protecting the community, and it's also about punishment. Sometimes people think the justice system isn't about punishment, but really, all these cases, there's an air of punishment involved, but hopefully rehabilitation. I know you probably think this is the end of the world. I came in here, I'm going to prison, but you're young, you still have a chance to get your life together. Please don't go to prison and get a bunch of tattoos, because you're clean shaven now. Please let it stay that way, okay? All right, thank you.
Make sure.
And